Okay, we'll call the legislative committee meeting to order.
Yeah, we are.
We have a motion approving the minutes of the last meeting. Motion by Evelyn, seconded by Matt. All in favor?
Aye.
Aye. Opposed? Carried. Okay, and we have a number of items on the agenda. The first item is something that I've been involved in. I think everyone's aware that last fall, the Fund for Lake George and the Review Board and several others drafted this a memorandum of understanding to try to get support for an Adirondack-wide invasive species prevention program. And DEC asked to have input into it, and they helped make some revisions. And then the governor's office said the governor wanted to do an announcement on it, and asked if we could quickly get some signatures, and so we sent it out, and it was amazing to me. We had signatures from towns and counties all over the Adirondacks, but also 3 state agencies, the APA, DEC, and Department of State. Oh no, Lake George Park Commission. So that was just a general statement that there was a need for this Adirondack-wide prevention program. And the governor included $1 million for the program in his budget, and then the legislature wound up approving it. But by the time all that happened, actually even before the legislature approved it, DEC started moving to try to have this plan in place for this year. Because of the time it takes for review of contracts by the State Comptroller's Office, they wanted to buy equipment and wound up, rather than buying the full recycling units like we have at Lake George and Loon Lake, they bought 9 $5,000 units, which don't have the recycling capability. They don't have onboard water, and they don't have the capability of suctioning up the water. So consequently, they need a disposal area, and they need a source of water, a 500-gallon tank, and you have to have somebody that's going to fill up the tank on a regular basis. So that's less than ideal, but the whole point of that was that they could do this contract for under $50,000, which is the threshold for the comptroller's approval. The other thing they did is they have a substantial payment that's going to Paul Smith College to administer the program, where some of us in the local government feel that we could administer it just as well if they changed it to a grant program. And the other thing, they only have like $8,000 in there for education, and there's a lot of support for possibly having billboards on the Northway or other education. The point of all that is just that the program, while it's good to have $1 million, many of us feel that it can be administered much more efficiently for next year. It's too late to do anything about it this year. But part of the argument when some of these issues were raised, DEC's argument and Paul Smith's argument was that it's too late to do this because it's just going to take much more time than we have to try to get this in operation this year. So the reason for the consideration of this framework agreement that's attached to your agenda is to try to see if there's support throughout the region for details which fix some of these problems. One would be to focus on the what they call spread pathways that are in this report. This is in Roman numeral 2, the report that was done by the Adirondack Park Invasive Plant Program on boat inspection and decontamination for aquatic invasive species prevention. Recommendations for the Adirondack region. They're good recommendations. I'll just hit some of the high points. One, the original drafts focused on trying to prevent at the border of the Blue Line any new invasives from coming in. Paul Smith College and APIP thought there should be also a focus on these internal spreads. So in paragraph, I guess that's paragraph, well, it's not a numbered paragraph, but it's this first full paragraph on the second page. There's an addition of internal. On the third paragraph in the bottom on page 2, there's a reference to support for an education program. On the bottom paragraph, to add billboards, because there's some possibility that the Fund for Lake George offered some money for the program, up to $50,000. One thought was to use that for billboards. Probably the most important paragraph is the first full paragraph on the third page. It would be support for a grant program for next year. So if this year the state has $1 million available, if it could be a grant program for next year, but DEC's made it clear if there's going to be a grant program, they have to start working on that now. They can't start thinking about it or working on it next January or February. So that's an important provision, to establish a matching grant program for public and private entities in the region to support purchase of decon stations and personnel costs and or staff additional boat launch stewards. So we think DEC is thinking along those lines, but this would give them a little nudge. And there was some concern that Paul Smith College is receiving substantial money this year. If you went to a grant program, they wouldn't be receiving the money next year, but they're okay with that. I've had conference calls with them. The third paragraph from the bottom on page 3 would be to have them manned 7 days a week from ice in to ice out. Right now, they're going to be doing substantially less than that on their hours of operation. And then the 215 program is all described on the bottom of page 3 and on page 4. And again, the second full paragraph from the top on page 4 talks about 40 hours a week. Paul Smith wanted to add the third full paragraph on page 4 to train, assign, and manage at least 14 additional boat launch stewards funded through the EPF. That's the source of the money, the Environmental Protection Fund. And then I think, again, the next most important part of this document would be the 2016 program to deploy additional boat launch stewards and inspection decontamination stations over what we have available in 2015. To set a goal for donations. There's some indication that if you can go to some of these private donors with a clear plan as to what the plan is for 2016, that there could be some substantial donations. So this would set a goal of $500,000 in private donations for 2016. And the second to last paragraph on page 5 just points out the role of the Regional Invasive Species Prevention Program's expertise by the Adirondack Park Invasive Plant Program, the Adirondack Watershed Institute at Paul Smith, the Lake Champlain Basin Program, because they all been heavily involved in this program as it is this year. And also the state agencies that we would ask the state agencies to sign on to this. DEC's indications are that they agree with at least most of this. They want some changes. Department of Transportation, the Office of Parks and Recreation, the Lake George Park Commission. And so I would ask for the committee's support for this agreement. I expect it to be basically in this format. It would be circulated. And it would be good if we could start with, Warren County approving it. Yes.
Thank you, Mr. Chairman. Did Martin have a chance to review this?
I sent it to him, but I don't think he's had a good chance to review it yet.
I've had I have reviewed it.
Yeah.
I'd like to do some more review.
Right.
But I think I can complete that review between now and the 19th.
Oh, okay, that'd be great. Yeah, super.
I don't
From
mind.
what I see,
Yeah. The whole point of the agreement, to me, it's less important exactly what it says, other than it's an indication if it gets broad sign-on. It's an indication of broad support for a plan that's somewhat different than this year, that we think, many of us think, would be more effective. The grant program aspect of it, following the science that's done by the invasive plant program. I think probably the single most important thing is the grant program, because if you have a matching grant program, that could leverage the $1 million into $2 million. it would help incentivize the private donations too, so. Martin, if Martin's willing to review it between now and the 19th, we can talk about any revisions that you might
I
have.
certainly am.
Yeah, okay.
Well, I'll make a motion, with the approval of our county attorney.
Right. Okay, anybody second? Seconded by Evelyn. All in favor?
Aye.
Aye, opposed, carried. Okay, the next item is the New York State Constitution, Article 14 Amendment to create a municipal land bank for utilities, highways, bridges, and small projects. I think many of us are aware that, the Constitution, Article 14, is the forever wild clause of the Constitution, creates an obstacle for many small projects, particularly in Essex and Hamilton counties, and it creates an obstacle for utilities. A couple years ago, there was a big problem with the utilities to the village of Tupper Lake, where all the utilities came from one direction, and to have redundancy, they wanted to bring power from another direction. And it made sense to the people planning the project to run it down a road, State Route 56. It comes from the north down into Tupper Lake. But unfortunately, there was a 2-mile stretch of state land along that road. So without a constitutional amendment, they had to avoid that. They couldn't run the power line through that stretch. So they designed a plan to go down the road, then go 2 miles out into the woods, 2 miles south through the woods, 2 miles back in the road, 6 miles to cover 2 miles, and with the associated environmental damage of having to clear for a power line going out through the woods. So everybody, including the environmental group, said that doesn't make much sense, so let's have a constitutional amendment. Then they drafted a constitutional amendment, and it passed 1 year. It has to pass 2 successively elected legislative sessions, passed 1 year, and then they discovered that there was some technical problems with the language. In the meantime, the deadline for federal funding to build the power line was about to run out, so both DEC and APA approved running it straight down the road rather than out around the forest preserve lands, which with real questionable legal authority to do that. But ultimately, the Constitutional Amendment passed after the fact. Another example was the Racket Lake water supply. They proposed a constitutional amendment to use 1 acre of forest preserve. So that again had to pass 2 legislative sessions and a statewide ballot to use 1 acre of forest preserve for a well for Racket Lake. We have the problem with the Middleton Bridge, where it makes sense to rebuild the bridge or to build a new bridge 2.5 miles north of where the existing bridge is, that goes from the town of Chester over into the town of Horicon up to Riding High Dude Ranch and the properties along there. And again, there's arguments that along the shore of Schroon Lake is forest preserve. There's arguments that it isn't also, which, and I don't know, could you just explain that briefly, Martin? What the arguments are?
Okay.
Yeah. And there's inconsistency to the way on the taxation and
Yeah, I think
DEC's position.
the land was deeded to the state back in 1979. This is the land of the Middleton Bridge land, and there's 2 20-foot wide strips along each side of the Schroon River. And it came from the American Graphite Company to the state of New York, and in the deed they specifically mentioned this provision of the Environmental Conservation Law, which says if land is gifted to DEC under this particular provision of the law, it does not become part of the state forest preserve. So that was the specific language of the deed. Notwithstanding that language, the state of New York, at least DEC, is taking the position that those lands are within the state forest preserve. What complicates matters is that there is an opinion from, State Board of Equalization and Assessment, that indicates that it's not in the State Forest Preserve. So, it would indicate that that means that the property should remain exempt state land, but if it's in the State Forest Preserve, it should be taxed. So the two agencies are in conflict with this land, which just raises additional issues, Mr. Chairman, for why, this land bank kind of makes sense.
Right.
To try to resolve these issues that are between these two agencies. And that's kind of been holding up, that's one of the reasons it's kind of holding up the Middleton Bridge project for Warren County. So, again, you have state agencies that among themselves can't even agree whether property is in the State Forest Preserve or not, but the state is reluctant to make an affirmative decision that it is or it isn't, because I think that just lends, sort of more difficulty to the conflict and begs out for resolution. So, this would be a way, I think, for a particular project, a small project, particularly where you have 20 feet of 20-foot wide strips along each side of the bank of the river, where the donor, the American Graphite Company, in their deed said specifically they do not want this going into the State Forest Preserve. The state takes the position, we don't really care about what the deed language says. We think it is State Forest Preserve language. We think it is State Forest Preserve, and as a result, we and the towns, the affected towns, are impacted by that and delayed by that seeming ambiguity, although frankly I don't see an ambiguity in it at all, but the state sees an ambiguity.
And we've had the same issue for years on the Skirting Manor property, most of which is in the town of Chester, where there's a similar clause, it might be the identical clause, in the deed, but DEC takes the position that it's Forest Preserve, and the Office of Real Property Tax says it's not Forest Preserve, so we're limited to Forest Preserve uses, but we don't receive the taxes. Now that's a related but somewhat different issue, but this issue of this inconsistent purposes has never been litigated in court, and there's no binding decision, and so you have a fight between two agencies. And so DEC, to their credit, there's been discussion in the local government for years about a constitutional amendment to create a land bank to deal with some of these problems with a limited amount of land. There is a land bank for state highways, and there was some discussion about the possibility of using that also, but this would be a land bank, to create a municipal land bank to deal with utilities, highways, bridges, and small projects like there's been constitutional amendments for the cemetery in Keene, and I think one in Paseco. There was one for the airport in Paseco. So I think this is something that Warren County should support, that all local governments should support, because it's a common sense solution to problems that otherwise require a huge effort in the state legislature and then a statewide vote. DEC has created a draft of legislation to accomplish this, and they haven't shared it publicly yet. I know their hope was to try to get it passed this legislative session, but there's only about 6 days left. But I think that, or I would ask that the committee support at least the concept, if the county attorney agrees, the concept of a amendment to the Forever Wild Clause of the Constitution to create a land bank to be used by municipalities for utilities, highways, bridges, and small projects. Okay, motion by Dan, seconded by Evelyn. Any further discussion? Hearing none, all in favor? Aye. Opposed? Carried. So I can get word to DEC that the county is supporting that concept at least. Okay, next is item 3 is town boundary issues presented by John Salvador. John?
We've had, this committee has had 2 sessions discussing this issue of the correct location of certain town boundaries.
Mhm.
You recall the first session, I presented, 1858 statute that clearly defined the town boundaries, particularly of Queensberry and, the town of Bolton. Subsequent to that, I came upon a map that, was made by the U.S. Census Bureau. And, they have clearly, mapped the town of Bolton on this map to be in full agreement with the 1858 statute. Since that time, I have come upon a series of maps done by the Conservation Department between 1958 and 1964. And the purpose of these maps was map the encroachments on Lake George around the shoreline. And so the whole shoreline of Lake George was mapped. I've got 2 copies here of the Dunham Bay to show that this mapping showed the town of Bolton to the west of the east shore of Lake George here on Dunham Bay.
Who did that map, John? I'm sorry.
Pardon me?
Who created that map? That's the
These
census?
maps were done by
The Census Bureau?
Blackwood, Kessler, and Bartlett, Inc.,
Uh-huh,
on behalf of the New York State Department of Public Works, District
Oh.
1, New York State
okay.
Department of Conservation. In any case, these are certified maps. Contrary to what we have been referring to, all of these commercial type maps that have been done, Town of Queensberry, Warren County Highway Department, Lake George Park Commission Boaters Map, these are all incorrect, but one has copied another. This mapping done between 1958 and 1964, it's conclusive that the boundaries are as they were set in 1858. And there's no excuse for not recognizing these. Every competent surveyor's office in this area has a full set of copies of these maps. There's gotta be hundreds of them around the lake. The Lake George Park Commission has file drawers filled with these maps. DEC Warrensburg has copies. I know Leon Steves has them. I know Tom McCormick has them. I know Dennis Dickinson has them. So it's common knowledge that the waters of Lake George are in the town of Bolton. I don't see any reason why we can't move ahead this the county, because in reality, it's the Washington County, Warren County line is not correct. That has to be, and then of course, if that's corrected, then the towns can follow suit. Now, on grievance day, I filed a grievance. It's not shown on here, my boathouse and 15 boat docks around it are clearly, according to these maps, in the town of Bolton. And our assessor has no jurisdiction there. So that's been taken under advisement by the Board of Assessment Review, and I'm expecting any day for their ruling on it. But, there should be no doubt of where the boundary line is, and I think we've got to, somehow issue an advisory or a resolution from the board, or a joint resolution, Warren, Washington County, straightening this out.
Is that, well, any questions anyone has? I mean, as I understand it though, our tax maps, you believe, are correct, they're consistent with these maps,
Well,
right?
the tax maps are an indication.
Yeah.
These are survey maps.
Right, no, I know that, I'm just trying to say that I think that the relevant departments of Warren County agree with your position, that's all I'm saying.
Yes.
Okay.
I mean, for what the tax maps are used for, they are correct.
Right. Okay. But beyond that, is you have the issue of taxation of your structures in the water, that's, right? Is that
Well,
right?
if the structure is beyond the town boundary, it's not in the town in which the taxes are being levied, it's incorrect.
The county attorney says.
Yeah, I note Supervisor Gerard, I think, has a question.
Okay.
I know you've done some work on this.
Have.
And it's confusing to me, the positions, not that you haven't explained it properly, just my level of intelligence, I think, understanding it. So I'd just like some clarity as far as where we're at and what he's saying and the implications.
I don't think there are any necessarily implications for Warren County as to what Mr. Salvador is suggesting. What he's presenting is not new. Supervisor Gerard, we've been over this for the last couple of meetings. I think the treasurer agrees with the maps. I think the treasurer agrees with the boundaries. I think the chairman has indicated correctly that our tax maps would indicate where the boundaries are. Mr. Salvador may have an issue with another government agency or two. I do not believe his issue is with Warren County. And so I've stated that opinion before. I'm going to state it here again today on the issue of taxation. I believe Lexi Deloria and or Mike Swan obtained a copy of a 2002 opinion relative to Lake George, actually, in the taxation or the assessment of boathouses on Lake George from New York State, which I shared with Supervisor Strau. I believe I shared it with the chairman here. I may have shared it with Supervisor Conover. I also shared it with Mr. Salvador. And that opinion states that, and it's a Lake George scenario, in other words. A boathouse is in Fort Ann, but it may extend onto Lake George, which is owned by the state, but it is in the town of Bolton, if you know what I mean. So, in that opinion, Mr. O'Keefe, I believe was an associate counsel or deputy counsel from the state, indicated that under his interpretation of the real property tax law, that is taxable, assessable property in Fort Ann, notwithstanding the fact that it may be located, the boathouse or the dock may be located within the boundaries of the town of Bolton. It is essentially accessible by Fort Ann. It is affixed to property that is in Fort Ann. It is an amenity of Fort Ann property, and I've opined that I would agree with that. If you asked me for an opinion on that, I would be giving the same opinion that Mr. O'Keefe gave, and I believe that there's some other opinions that may support that as well. So that may be an issue that's before the Town of Queensbury Board of Assessment Review, perhaps the Bolton Board of Assessment Review, perhaps the Fort Ann Board of Assessment Review, but that's how I see it, and as I've explained to the chairman, and I believe I've explained to others, I do not see any action that is needed by this committee, and I'm not recommending any action.
I addressed, when you sent me a copy of that letter, and I addressed those issues. Firstly,
Where did you address them?
I sent you a letter.
I don't believe I got that letter. I'm sorry. I'm sorry.
I'll get a copy. In any case, when the town of Fort Ann undertook this investigation, this issue, number one, they had no appreciation of the fact that the town boundary was in the wrong place. Absolutely none. Okay? Now that's a big issue here. And the fact that you can enter the boathouse from the town of Fort Ann is irrelevant. It's irrelevant. I've heard people tell me, well, you got a benefit from the fact that your boathouse is in another town. I got a benefit. I got a benefit from a lot of things outside my town boundary. That's irrelevant. That none of these opinions that have come down from ORPS are predicated on the fact that what is being assessed is outside the boundaries of the town.
Mr. Chairman, Mr. Salvador, I have to respectfully disagree, and you and I have had many conversations on this point.
Yes?
I'm reading from the August 1, 2002 opinion from Mr. O'Keefe. He writes, "As you describe the situation, the boathouses are secured to the upland in Fort Anne as well as to the bed of Lake George. The boundary of the town only extends to the shore of Lake George. The boundary at that point is with the town of Bolton, Warren County." So I believe Mr. O'Keefe was aware of the town boundary at the time that he issued his opinion in 2002, sir.
It's,
I mean, it,
The
I mean, it seems to me
definition-
the crux of the issue is, that's an opinion of ORP's,
This is an opinion, at that time, the Office of Real Property
Real Property,
Services, I believe they may have
which
changed
is
their name.
their opinion, and the court could later differ, but that's, but, correct me if I'm wrong, but I think that the county's position is that that's an issue that Mr. Salvador or anyone else can take to court, and you might or may not prevail on it, but it's not an issue for us.
That's my position.
Okay. Yes. Let's wait for
The-
Mr. Salvador to finish, and then I'll
the,
recognize.
the town boundary referred to there has no definition. Absolutely no definition. Where is it? Where is the shore? And is it connected in the town of Fort Anne? At what elevation? Every one of those lots is different. It becomes necessary for us to define, analytically define the boundary line. And as I've suggested, the mean high water mark is the logical definition. And then everybody knows, and then you can determine whether or not that boathouse is attached to the land in the town of Fort Anne or not, once you know where the boundary is. My boathouse is not attached, my boathouse that is in the town of Bolton is not attached to land in the town of Queensbury. Okay, so it may be accessible, but that's irrelevant.
I think we have a pretty good understanding of what the argument is, and I still don't quite understand exactly what you're proposing that we as the county do. I mean, I understand your situation, I understand that is something that could be decided in court, but I just don't understand what exactly the county could do about this situation.
Well, first of all,
These three maps are incorrect. They are incorrect.
That's
They're
fine.
on the street,
They're not really relevant, though. I mean, there's a lot of things that are
Mr. Stroud-
incorrect that we're not gonna try to correct, but.
Mr. Stroud relies on these maps,
Yeah,
okay?
okay,
That's what Mr. Stroud was relying on.
yeah. Okay, well,
as I say, it's before our grievance board,
uh-huh,
and, I did get some nods when I was presenting it to the grievance board. I
Ah,
did
really?
get some affirmative nods, so.
well, I think our position is that's the proper approach, isn't it? That, to go through the town procedures
Yep, but
on
I-
assessments.
I think the last time, Mr. Salvador, the last time we met on this was before grievance day, I think. And I think it was discussed, I believe you represented at that meeting that you were going to go to grievance day and
Yes.
file grievances.
Yes.
So, yeah, so it was before
Yeah.
grievance
And
day.
I-
So
and I
we
did.
knew that was the process.
Right,
And I did.
okay.
I don't know how many others have. But I mean,
We should be
That's-
getting a decision pretty soon there, right? They only have so much
they said
time.
2 weeks, it's imminent.
Okay.
Okay. Any other discussion by the board? Mr. Weinschenk?
My name is George Weinschenk, and I basically came across this problem in the early '80s, and since then we've gone nowhere with it. The letter that the attorney just read kind of stated that the boathouses are not on town property, they're on state property. Well, let's go back, there's two issues that you gotta deal with. The first one is this issue here, which John brought up. It's very clear that all of these boathouses, if they're beyond the mean high water mark, they're in the town of Bolton. That's according to this. So let's stick with that for a second. What that means is Queensbury, Lake George have been collecting taxes on property that's not in their town. And as a result of that, their assessments are higher. With the higher assessments, that's mean they're taking tax money from all the other towns that are not on the lake, because their assessment is artificially high, and it shouldn't be there. Now, you got the tax warrants coming out in another couple of months, and this should be dealt with before the tax warrants go out. You're aware that these are artificially high, they have to be dealt with. They're gonna be dealt with sooner or later anyway. Either they're gonna go to court eventually, or you take and do the job you should be doing and saying, look, this is wrong, let's start straightening it out. The second decision was the decision by Dave Krogman, the judge, who said you don't have the right to tax these properties
Excuse me.
on it.
Mr. Chairman,
Yeah.
Judge Krogman's decision did not reach that issue, respectfully. This has been brought up before this committee before. I have to correct that, and I corrected it last time. Judge Krogman did not reach that issue about taxation of those structures. As a matter of fact, these opinions from the state cite Real Property Tax Law 546. In these instances, if you have a structure, if I build a structure, and I own the adjoining land, and that structure is on state land, these opinions opine that that structure is a taxable assessment to me, even though it's on state land.
All right, let's stick with that for a second.
I just wanna clarify that for the record, because sometimes we need to just kind of focus on exactly what the issue is. I wanna reiterate that Judge Krogman's decision went to the authority of municipalities under their land use codes to be able to approve or disapprove or permit docks and boathouses on Lake George. He did not reach the issue of taxation, and I believe Dave Rosebrook was here last time, agreed with me. I believe Mike Swan was here last time, agreed with me on that.
Let's stick with that for just 1 second. What you're saying is, I can come along and on state land, build anything I want, providing it meets the state law or whatever it is. And the town can say nothing about it, but when it's all finished, the town can tax it. That's what you're saying.
No, I'm not saying that. I'm not saying that. Yeah,
Well, you just said the towns have the right to tax it.
I don't, this is getting argumentative, Mr. Chairman. I'm only saying what Judge Krogman's decision didn't say, and I'm also saying what the statute in these opinions, the cited statute in these opinions says. That's all I'm saying.
And what his decision said is that the towns have no right of anything on this.
Well, no, I mean, attorney reviewed it, and he says it did not address the taxation or assessment.
Mr. Weincheck, the judge did not say the town has no rights of anything on this. The judge did not say that those are not, that is not taxable, accessible property. He did not reach that issue.
But he did not say that it's taxable by the towns either.
But that issue wasn't before the court, sir.
Yeah.
All right, well, let's stick with this on it. Let's go back to this whole basic thing. If none of these properties, according to the maps going back to the 1800s, are in the towns of Queensbury or in the towns of Lake George, how can they tax those properties?
That issue is before the town of Queensbury Board of Assessment review. There are, and I'm just citing for the record here, there are opinions from the State Board of Equalization or the Office of Real Property Services, its successor, which seem to support an argument, or at least it's their opinion. In your instance, at least it would be their opinion. If I were reading these decisions, I would conclude that that a dock that is affixed to land in the town of Queensbury, which may be located or extended over the boundary into the town of Bolton, is accessible, taxable Queensbury property. That's all I'm
All
saying.
right, let's stick with that argument then.
I don't know that we can...
I come over a bridge from Saratoga
Well,
County to Washington County all the
Mis-
time.
Mr. Weinschenk, you know, we allow public comment, but we have a fairly long agenda.
I agree.
I think the county attorney's opinion is fairly clear, and it seems fairly clear to me that the only way this is ultimately gonna be resolved is through the court, because we've got opinions that don't agree with what you're saying. I think Warren County agrees with Mr. Salvador's position as to where the boundary line is, but there's a remaining question about the assessment. We've got some fairly clear opinions but they're not necessarily binding on a court, and the only way it's gonna get resolved is through the court, I think.
Just one last quick thing. Like I said, I come over from Saratoga County to Warren County over the bridge. Does that mean Warren County is part of Saratoga County 'cause it's connected by a bridge? What's the difference between a bridge and a dock?
All good arguments for court, I think. Mr. Salvador?
None of these opinions from the state have dealt with the issue that we pay the state a fee
Back fee, right.
to occupy the state land, okay? And as such, those structures are registered annually. We pay an annual fee. We are tenants on the state land, okay? And I don't think it's proper for the town to issue a tax bill to a tenant without the tenant's permission. Now, none of those issues you mentioned, those opinions, have ever addressed the fact that we are paying a fee to a state agency for the occupation of state land.
One thing I'm absolutely certain of, Mr. Chairman, is that that is not an issue for this county.
Okay,
But it is an issue before the BAR.
yeah, okay, thank you, Mr. Salvador. Okay, we'll move on to public commentary draft policy. That's what we're dealing with, actually. But I think it's good. I don't think we've ever had.
Should've done that first.
Maybe we should have. I don't think we ever had one for the committee meetings, at least. I think there's been one for the rules of the board, but full board. In any event, Martin has drafted this, and I reviewed it. I think it's pretty good. I think it was sent out to all the supervisors. You want to explain it, or did committee member want
Does
any
anybody,
questions?
first of all, does everybody have a copy in their package?
Right.
This has been, Mr. Chairman, this has been being talked about for, I think, the last several months anyway.
Right.
We've talked about it here off and on. I have put this together, and the idea was to bring some structure to the public comment period of both committee meetings, regular meetings, special meetings, and also public hearings. What I tried to achieve here in the overall was, yes, bring some structure, but also afford the chair broad discretion, whether it is a special meeting, regular meeting, committee meeting, public hearing, whatever the case may be, to afford additional time, depending upon perhaps the length of the meeting, depending upon the importance of the subject matter, depending upon the differing opinions, and also try to give the chair some guidelines and assistance with when would this be allowed? Well, it would be allowed if the comments are not going to be redundant or repetitive of something that's already been made, or if it's something of a critical matter, something that's very important to Warren County, or very important to a property owner within Warren County, as the case may be. So it provides structure. I believe that was the task, was for me to put something together for you that provided desired structure for our meetings, but at the same time gave us ability to be flexible within the discretion of the chair. So it, as you can see, it includes a purpose and scope section. It addresses in section 2 regular and special meetings of the Board of Supervisors and public hearings. We also from time to time receive presentations. We've had presentations at this very committee from time to time. For example, the presentation that we had at the Board of Supervisors meeting, and maybe we had it here, or maybe we had it at another meeting, about the marijuana, what do we call those? Medical marijuana facilities. Yep. I talked about here about generally the time allowed for presentation shall not exceed 15 minutes, but again, generally, so that there's some flexibility there. There's a section on regular and special committee meetings. So during a committee meeting, for example, public comment would be allowed during the following periods. 1, during a public comment period, provided such comment period appears on the meeting agenda. 2, at the absolute discretion of the chairperson following a scheduled presentation to the committee as appears on the meeting agenda. And then 3 is the catch-all. Such other times as within the absolute discretion of the chairperson. Section 5 addresses public comments and time limitations applicable to all Board of Supervisors regular or special meetings, committee meetings, and public meetings. There it's limited to 3 minutes, but again, there's flexibility for the chairperson to allow for additional comment by an individual who has previously provided comment during the same meeting or public hearing on a subject matter. In order to request additional opportunity to provide comment, the individual must first be recognized by the chairperson. The individual will then approach the podium, state for the record the subject matter for which they desire to make additional public comment. In all instances, the chairperson shall have absolute discretion to allow or disallow the additional public comment. Any additional public comment must be relevant and material to the subject matter of the meeting or public hearing and shall not be repetitive or redundant of comment previously provided. I also added that notwithstanding anything in this policy, the chairperson may at any time recognize or call upon a supervisor or a department head at any time to answer questions or to provide comment. I added a provision that says no person may assign their comments or time period to speak to another person. In Section 6, how to address the committee. Section 7, decorum and etiquette. I've added that provision, and then there's the standard severability clause, which we typically put in these types of things. So that's the sum and substance of it. This is actually what you're seeing today is, I believe, the second draft of the document. If you're comfortable with it, let's move forward. If you're not comfortable with it, let's have further discussion on it and send me back to the drawing board.
I think it addresses the issues I've heard. Any committee member have any comment on it? Yes, Evelyn?
I know after the first draft, I sent Martin some comments. I see they're all incorporated in here.
Okay.
I think it came out very well, and I would make a motion that we approve it.
Okay. Seconded by Matt. Any further discussion? Hearing none, all in favor?
Aye.
Opposed? Carried. So thank you for Martin.
You bet.
Very good job.
And
Thanks,
Mr. Chairman, I'd like to mention something you mentioned to me before the meeting got started, is that this is not a local law. If we decide we want to change this,
Yes.
we can change it at a meeting.
Right.
You know, it'll be adopted by resolution, it's a policy, it can be changed by resolution very easily, very quickly too.
Right. Okay. Okay, so I think that's a good step. Okay, next item is referral from the Public Safety Committee requesting action urging the county's legislative representatives to seek the expenses associated with river gauges to be funded on a federal level. I think recently at the Public Safety Committee, which Evelyn chairs, she was presented with information that the expense of operating the river gauges is proposed to be imposed on local government. And my understanding that always in the past, the U.S. Coast and Geodetic Survey paid for the operation of those river gauges, which seems to me very appropriate. And so, at the Public Safety Committee, it was voted to refer this issue to the Legislative Committee. Did I state that right, Ellen?
Yes, that's
Okay.
pretty accurate, yes.
Okay. So, I feel that our position should be that we request our federal representatives to take this up and to try to adopt legislation which says this is a legitimate, a proper federal government function and that should be paid for by the federal government. Do you have any other opinion on it, Martin, at this point?
I don't.
No.
I'll move it.
Okay. Motion made by Dan, seconded by Edna. All in favor?
Aye.
Aye. Opposed? Carried. Okay, next is legislation forwarded by Wyoming County in support of the New York Senate Bill S-4240, New York State Assembly Bill A-6245, amending the county law in relation to community and economic vitality, nutrition, healthy families, and 4-H youth development under a form of organization administration approved by Cornell University. So it's requesting statutory change to the mission of Cornell Cooperative Extension, eliminating the outdated term home economics and focusing on economic and community vitality, nutrition, healthy families, and agriculture. Specifically recognize youth development in 4-H as a mission for Cornell Cooperative Extension. The extensions are unique in that much of it funding depends upon strong support from fiscally strapped county governments. Urges the legislature and the governor to pass Senate Bill S 4240 and Assembly Bill A 6425, which would make that change in state legislation. Matt, are you moving that?
Please.
Matt? Okay,
I'll second it.
Evelyn seconds. Any further discussion? Hearing none, all in favor?
Aye.
Aye, opposed, carried. 7 is legislation forwarded by Fulton County requesting the governor and the state legislature to amend the vehicle and traffic law to allow all-terrain vehicles up to 1,500 pounds to be registered. Actually, I'm very familiar with this because this is a resolution that was passed by the Local Government Review Board and sent to all the counties, and this, Fulton County sends it to Warren County, asking Warren County to support it.
I'll move
Ye-
it.
Yes.
I'll move
Do you
it.
have a question? Oh, okay, you're moving it, Dan? Okay. Anyone second? Seconded by Edna. Any further discussion? Everyone understands the issue that you can't register these, they call them UTVs. Many of them are side by side, and they're bigger units, but they weigh 1,500 pounds, and New York's the only state that says you can't register anything over 1,000 pounds, so this would allow registration up to 1,500 pounds. But it's become a real Adirondack issue because there's a bill in the legislature. Actually, I was just down there yesterday, meeting with some legislator about it, that would prohibit in order to get this change in the law, that would prohibit use on the forest, any place on the forest reserve. So, I think our position should be, this is a change that should be made. It shouldn't have anything to do with the Adirondacks, at least at this point. So, any other discussion on it? If not, all in favor?
Aye.
Aye, opposed, carried. And let's see, 8 is also legislation forwarded by Fulton County requesting the governor and state legislature to amend the vehicle and traffic law regarding designation of highways and for travel by all-terrain vehicles. This is another one that came from the review board, that the language of the statute, vehicle and traffic law, section 2405, provides that towns can designate sections of town highways for travel by ATVs where it's otherwise impossible to connect two segments of a trail. And towns in the Adirondacks request a change in that statute to remove the otherwise impossible language, to give the towns more flexibility to allow trail connections using town roads. That's what it boils down to. Anyone have any thoughts on that?
I have a couple points of
Evelyn,
clarification,
okay.
just because we had a similar issue with this
Yeah.
in my town a while back. With this, are we asking that to apply just to towns, or are we taking it out of and putting it in vehicle traffic so it'll apply to all roads within the town? Like in Thurman, we have a lot of county roads,
Right,
and my concern is like from a liability standpoint, sometimes you get people running along the edges of the road, it damages your pavement, wipes out your shoulder. Occasionally there are accidents.
right.
I'm not sure what the liability is in for that, and I have some concerns therein. I think it's a worthy thing to connect trails, but I think we also have to be careful about infrastructure getting, you
Yep.
know, it's bad enough
No,
as it
it's
is.
a valid concern. Yeah, and I don't think a town has the authority to designate a
No.
county highway as
Well, that's why I
a-
was wondering,
for
because
ATV use.
if we're trying to do just town, or if by removing that language from the state law, is that opening up the county roads as well, or?
Right. Well, maybe at this point we should just refer it to Martin to look at it and give his opinion.
That's right, I'm
No,
sorry to
impact
throw
the
it back
county.
then, but I was just curious.
Because we don't wanna do something that's gonna hurt the county. That sounds reasonable?
Yes.
Table it for this meeting?
Okay. fine.
Okay, we have you moved
I'll
to
motion to
table.
table.
Any second? Seconded. All in favor?
Aye.
Aye, opposed, carried. Well, I think we did pretty good. We had a long agenda. We did it in under an hour, yes.
Privilege of the floor.
Yes, okay. Oh, okay. Bob?
Mr. Chairman, I had previously brought to the board, the issue of the lack of proper civic education in our schools, and also the, state and our schools' participation in the park consortium for the, Common Core Standards assessment and the unconstitutionality of that. My last appearance here, Martin had indicated he had sent a letter to, I believe he said, the State Board of Regents, the State Education Commissioner, and each of the regional school districts in the area. Do you have a report, Mr. Averdu, do you have a report what's happened since my last appearance?
We've received no response to my correspondence.
Okay, I have a letter here that, in that event, I have a letter here which, is addressed to the chairman and the members of the Warren County Board of Supervisors and the chairman and members of the Washington County Board of Supervisors, the supervisor and members of the Queensbury Town Board, supervisor and members of the Fort Anne Town Council, and the president and members of the Lake George Board of Education. And I'll have a copy for you when I'm finished. So it's addressed to the guiding heads and members of those organizations. It says, I am a citizen taxpayer within each of your jurisdictions. On February 3rd, 2015, I served each of you with a First Amendment petition for redress of grievances regarding the unconstitutional behavior by an element of the government within your areas of jurisdiction. That is, civic education in the public schools does not comply with state education law, Section 801 and 802. And the public schools are participating in a multi-state assessment consortium, an assessment system based on the Common Core Standards in violation of the Constitution for the United States of America. The petition for redress included statements of fact and remedial instructions in the form of 2 resolutions. One that would have your honorable assemblages call on the State Board of Regents to amend the Social Studies Learning Standard for Civics, Citizenship, and Government to bring it into compliance with the state education law, and a resolution that would have your esteemed bodies call on the state legislature to discontinue participation in the unconstitutional multi-state park consortium in favor of an independent state-based approach to the improvement of education in New York State. Notwithstanding these violations of the rule of law, your individual oaths of office to support and defend the New York State and United States Constitutions, your individual pledges of allegiance to the Republic, often repeated since your receipt of the petition for redress last February, and your obligations to respond, I have received no response from any of you, and of course it's being addressed to the 5 bodies. Any unit of the government that first ignores the Constitution, knowingly or unknowingly, then ignores the people's fundamental right to hold them accountable by claiming and exercising their First Amendment right to petition for redress of those grievances, calls into question the legitimacy of that distinct part of the whole. The matter becomes one of extreme importance, especially to those individuals like me who have taken the oath to support and defend the constitutions from all enemies, foreign and domestic, and who are dutiful and thoughtful enough to recognize the inherent danger of the people failing to hold the government accountable to the rule of law. Here's a quote from Jefferson in that regard. A departure from principle in one instance becomes a precedent for a second, the second for a third, and so on, till the bulk of the society is reduced to a mere automation of misery, to have no sensibilities left but for sinning and suffering. That was Jefferson in 1816. So the question becomes, what can I do about your refusal to respond responsively to these proper First Amendment petitions for redress of these grievances? I could petition the judiciary, but by the time the matter was fully resolved by the courts, our public school children, including my grandson and granddaughter, will join the countless others who have not been properly prepared for their civic lives. Instead, I've decided to embark on a hunger fast, beginning July 1st. If before then I have not received a written response from each of you, a response in which you either refute the facts stated in the resolutions or agree to the remedial instructions, beginning July 1st, I will consume only water until the day that I receive such responses. So I humbly beseech you, true to your oaths of office, to support and defend the constitutions by adopting the resolutions. Copies are attached. Or by responsively responding to the petition for redress. Thank you for your service and your attention to this matter.
Okay, thanks. Do you have copies of that for us, you said?
Copy of each of the 5 petitions.
Okay. Put 'em on there. Okay, any other business for the committee? Add a motion to adjourn. Evelyn, Edna, all in favor?
Aye.